Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I'm Thomas Vick, joined by my co-host Seth Wilson. Seth, how are you today?
I'm good, Thomas. How are you?
I am doing well, doing well. We had another blog digest go out today. Had a couple different topics that were discussed in the blog digest. One was some tips about estate planning, kind of a general uh, handbook, if you will, about what to think about when you're doing estate planning. But then another interesting topic was sent out, and that was feud-free estate planning tips to pass on family heirlooms. I thought that was an interesting topic. What were some key points that you took away from that topic?
Well, first, just the reality of what happens in the division of that personal property. So these family heirlooms, not always with a significant amount of financial value, but definitely that sentimental value, and there's value to the recipient. And sometimes you don't even know about it, right? You may not have ever known that your sister or your brother really wanted whatever item that may have been, and all of a sudden you realize, oh, I wanted it too. And now, how do you figure out how best to distribute that? So, I always go back to, did you ever fight with your siblings growing up? I think we all grew up in households with siblings. You probably had a fight or two with them, right? So this
Yes.
is this is where that kind of comes in. And I love the first point on the article, which was don't burden the executor or the personal representative with helping divide that or fix that squabble, so to speak. You can be very helpful in your planning if you're a little bit more intentional and thinking forward. So, how do you normally handle that, Thomas, in the estate planning context? Do you put all of that into a will or a trust into those terms?
Occasionally, so it depends on what type of property we're thinking about. I actually had a recent one where burial plots were distributed through a will. That's not really tangible personal property, but it's a specific distribution, and we just made it clear that these certain plots are going to go to this particular person. You know, I think it's really helpful to have a tangible personal property memorandum where an individual can write down their list. Seems like people that have a lot of tangible personal property that they care about already kind of have their own list, and they might even bring it to the signing appointment and say, "This is what I want to see happen." But we can make that official if we incorporate it by reference in the will or trust, and then that tangible personal property memorandum can be executed, at the time of the signing of the will or trust, or it could be changed after the signing of the will or trust. So you don't have to come to an attorney's office and redo the will or redo the trust to get something notarized. You can just write it down and keep it alongside your will or trust. And that's typically how I handle it, and clients are generally pretty happy with that strategy.
Yeah, I agree. It's such a great tool because to have all those decisions made and form up your initial estate plan or make an amendment, that's a big ask for yourself, just in terms of trying to fast forward and go, okay, where does all the stuff, so to speak, go? And that can be overwhelming. And so I I like the ability that we have to hand off that document and say, hey, over time, you can add to, change, do what you need to do with this list. Just make sure that you follow the proper execution principles to get it signed so it's binding. But that, even if it isn't, it's still better evidence for the beneficiaries to know, well, this is really what mom and dad wanted to have happen. And so then the personal representative at least has something to help clarify what the overall intent was. But again, making sure that's done properly, then it is binding. And this is how it's going to happen. And so I agree. I think it depends on the type of asset, whether you actually want to list that as a specific distribution in your estate planning documents, or if you are able to kind of handle that in terms of the personal property memorandum.
Yeah,
So
and the type of asset is so important. You know, if you've got a painting by Van Gogh, you probably want to put that in your will because you probably don't want to leave any doubt, you know, as to who that is supposed to go to. Um, and having one of these memorandums is helpful because it cuts down on attorney fees. You don't want to have to come back and revisit the will, revisit the trust, and get an amendment just because you know somebody maybe passed away and you need to update it. You can make that update on your own. So I think it's helpful from that standpoint. Um, on the point in the article about don't burden the executor, um, you know, it certainly can be a burden. I think one of the examples in the article mentioned like there were 19 beneficiaries and there was a ton of personal property that had to be distributed, like 12 vehicles, a water well drill rig, two semi trailers of car parts, guns dating back to the Civil War, and reportedly the decedent told his son that his son could handle it and handle the stress of the people who quote aren't going to be happy. Uh, I don't know that that's the best way to handle it, and it sort of made me think of a story that another attorney uh, that I don't really know him. I was actually in the middle of sort of a contested estate with him, but he told me about uh, a contested estate where it got down to I don't know a piece of jewelry. It wasn't valuable jewelry. It was purely sentimental, and two daughters were the beneficiaries, and they couldn't decide on who should get the jewelry. And so what the judge did was just have the attorneys go back to their office with their clients and do an auction and say, are you going to pay $5 for this or $10 or $15? And it goes to whoever the higher bidder is. It's crazy how people can get so caught up in the contentiousness of the tangible personal property and who's going to own it. And so easing that burden with clear instructions in your will or trust, and also clearly writing down in a tangible personal property memorandum who will get the property. Those are great ways of easing the burden of on the executor.
yeah, it's a great point, and I think too there it doesn't have to be, you don't have to spell out that you're going to give the first three forks in the silverware drawer to the oldest child. It doesn't have to be at that level of detail, right? You want to make sure that these are the things that your beneficiaries, your kids may have an interest in and help decide that. And you can have those conversations with the kids and get some feedback from them as you're thinking through, hey, who would maybe want to take this piece? Maybe it's an antique piece or something like that of furniture, and who would be more interested in these kind of things. Or, there's ways to do that by category of items rather than spelling out everything in finite detail, because you don't have all the time in the world to sit down and just figure out where all this stuff goes, nor does anybody want to have to follow that level of detailed instructions. We need, we trust the people that we're putting in these roles oftentimes to have some good discretion, but also give enough clarity to reduce the potential for any type of fight over where that might go and what the intent was of that. So good points there as well. And I think the final kind of point that stuck out to me on the article was talk with the attorney, because you mentioned a couple of experiences that you're familiar with that you can relate to and relay to the clients as they're thinking through what are some of the options. Okay, you could put that type of auction language into a document if you wanted to say, hey, if there's any question here after the division, anything that there's a question about, this is how we're going to resolve that question. And so that can be a creative way as well of helping sort of in case of dispute, then this is how we resolve it, be it a coin flip or something like that.
Yes, yes, and I think sort of my default language on personal property that isn't specifically distributed through the will or trust is everything to the kids as they agree. And then if they can't agree within 6 months, then the personal representative can take over and do a lottery system or, draw straws or that kind of thing to make sure that, we're doing it in a fair division. So yeah, I think, our not to toot our own horns, but you and I do this every day, and so we've got the experiences to draw off of, and we can kind of see what the outcome has been in the past, and how we can have that same good outcome, or how we can have a poor outcome if we do some make some bad choices. So, um, yeah, I definitely agree with that point. Talk to an estate planning attorney about these specific distributions.
Good points there. And it's always fun to hear from our clients as to what kind of things they have to transition, right? And so there's different types of collections that folks have, or something unique that you might not run across. And in my world, when I come across that, I always ask a lot of questions because I want to understand what might be the market for that potential collection. If it's something that's not very common in our marketplace, or it's a very niche type of collection, it may have a lot of value to the family, where on the open market it may not. And so that puts the personal representative in maybe a difficult situation if you're trying to fairly divide things up, if there's no specificity as to that specific item and how it's to be distributed. So that's the other side of the coin, I think, as well. No pun intended, I guess, when we're talking
Yeah.
about finances. But you want to figure out how can we put some sort of value on this so that it can be equally divided, or if one beneficiary would take that, what's the corresponding value of another item of personal property?
Right, right. Well, good stuff, Seth. Appreciate it as always. How can people get in touch with you?
Thanks, Thomas. We are here in the heart of Hamilton County in Noblesville, Indiana, and that's the easiest way to find us is go to our website, noblesvilleattorney.com. How about yourself, Thomas?
And I'm Thomas Vick. I'm the attorney at Vick Law PC in Greenwood, Indiana. And the best way to get in touch with me is to go to my website, vicklaw.org. Appreciate it as always, Seth, and then we'll see you next time.